People versus Robert Durst. Counselor appearing for him pursuant to a written waiver 977B. Mr. Durst is not present, but Mr. Lewis is present. Good to see you again, Mr. Lewis.
Likewise, Your Honor.
And on the telephone?
Good morning, Your Honor. David Chesnoff appearing on behalf of Mr. Durst. Also on the line is Mr. Dick DeGuerin, Mr. Donald Ray, Lois Haney, our jury consultant's on the phone, Mr. DeMarco from my office is on the phone, and a lawyer consulting with us from San Diego by the name of Mr. Chuck Sevilla is on the line as well, Your Honor.
Very well. And we have Mr. Lewin present. Who else is present from the people?
We've got Mr. Balian, Mr. Henderson, Mr. Miata, Mr. Milius. We have Detective Camacho and Detective Shamlian. And Detective Bankson.
Thank you. All right. First, I wanted to alert counsel that we received two communications. I'm sorry. We also have Mr. Were you speaking, Mr. Chesnoff? Did you have something to say?
No, I didn't say anything, Your Honor.
All right, I heard a sound coming from the speakerphone. I thought it might be you.
No, but I've asked my other colleagues to mute their phones, Your Honor. So I hope. Okay, thank you.
Thank you. First, I wanted to alert counsel that we received two communications from jurors. This is from juror number 5, who asked to be excused due to a health concern that I won't share now, and juror number 10, who generally did not ask for excuse, or to be excused, but did describe some health concerns on account of the pandemic. I'll get back to that issue a little bit later. On the renewed motion for a mistrial, which I received July 2nd, I would say that defense counsel does make a good point, but that point wouldn't really change the outcome of the motion. My tentative ruling would be to, again, deny the motion for a mistrial, but I'll hear from defense counsel if you wish to be heard.
I do, Your Honor, and I appreciate the opportunity to make a complete record here. As the court just noted, we have filed a renewed motion for mistrial as well as a motion to adjourn. During the hearing on June 23, Your Honor, this honorable court stated in part at page 39 of the transcript, if we come to the point where we believe it's not safe, we won't continue with the trial. We're not going to expose people to this illness. This situation now, Your Honor, is far worse than it was on March 12th. We strongly believe, in light of the serious pandemic which continues to worsen, the court must grant a mistrial. At a minimum, an adjournment must take place, but we are not waiving any rights by suggesting this alternative choice, as we respectfully submit a mistrial as the more appropriate remedy. A mistrial should be granted because the coronavirus surge is worsening, as is a severe health threat to all, and would not only jeopardize the health of the court and staff and jurors and spectators, but the health of counsel, and Mr. Durst would be deprived of his Sixth Amendment right to counsel of his choice as a result of 3 of his counsel's doctors' directives not to return to Los Angeles at this time to try the case. It's our belief, Your Honor, that the current trial as a matter of law has been irreparably damaged, and we should not go forward with this jury. We also face a grave risk of irreparable damage to all of our healths, including I left out the district attorney a short while ago, and I didn't mean to, because we're as concerned for them as we are for ourselves. While defendant Durst maintains his objections and renews his request for a mistrial in this case, in the event that this court denied such relief, defendant had no choice but to respectfully request an extension of the adjournment of the trial due to the ongoing unprecedented issues presented by COVID. As of yesterday, according to the CDC, there have been over 3 million reported cases of COVID-19 in the U.S. and approximately 137,000 deaths so far. The cases are rising, and the state of California, more specifically Los Angeles, is a danger zone. As of last night, the California Department of Public Health has reported over 356,000 cases and 7,345 deaths in the state. The data reported by the LA County Department of Public Health reflects that Los Angeles now has a shocking 147,000 reported cases and approximately 4,000 deaths in LA County alone. It was reported yesterday that the LA County Department of Public Health confirmed 59 new deaths and 4,592 new cases of COVID. This is the largest increase in new cases in LA since the pandemic began, surpassing the count from just 2 days before of 4,244. It was reported yesterday that over the last 48 hours, there have been 7,350 new cases. COVID-related hospitalizations are also at a record high. The number now is 2,173 people on Thursday. That surpassed the old record of 2,103 people hospitalized, which was set on Tuesday. Younger people are being hospitalized at a higher rate than any other point in the pandemic, comprising 20% of those undergoing and needing care. The long-term health effects on young people may not be completely known for some time. According to an article yesterday, those numbers come on the same day the state of California reported that its 7-day running average of daily new cases totaled more than 8,000 for the first time. That average has risen 295% in the past month. We are seeing a higher rate and higher numbers than we've seen before, said Los Angeles Public Health Officer Dr. Montu Davis earlier on Thursday. Dr. Davis indicated health officials are worried about hospital and ICU capacity. He said all the hospitals in the region are, quote, looking at implementing surge capacity, end quote. Asked when those beds may run out, Dr. Davis said at this point we don't have an accurate number of trajectory. As to when the county will be out of ICU beds, he said the numbers are skyrocketing. The number of ICU beds is more limited and health officials are closely monitoring the situation. Just this morning, Your Honor, news reports indicate that there is an unpublished document prepared for the White House Coronavirus Task Force and obtained by the Center for Public Integrity, a nonprofit news organization, which recommends that 18 states in the coronavirus red zone, including California, roll back reopening measures amid the surging cases, which also includes limiting social gatherings to 10 people or fewer. The city of Inglewood has very high numbers with reported cases of 1,488 and 70 deaths. On the 13th of July, Governor Newsom ordered restaurants, wineries, movie theaters, family entertainment centers, zoos, museums, and card rooms, gyms, salons, churches, and malls to reclose indoor operations in 30 counties, including LA. Mayor Garcetti recently warned the city is on the verge of shutting down again. On July 15th, due to increased COVID-19 infections in the county, Los Angeles County Superior Court presiding Judge Kevin Brazil amended his July 10th order and announced again the delay of criminal trials. Under the order, among other items, the deadline for holding a criminal trial under the California Speedy Trial Penal Code 1382 was extended by up to 30 days, applicable to only to cases in which the original or previously extended statutory deadline would expire from July 15th to September 14th inclusive. Thus, a defendant who would invoke a speedy trial would have his trial continued possibly up to September 14th, yet Mr. Durst, who has not invoked that right and is at high risk, along with 3 out of 4 of his counsel, could be forced to trial in the middle of a pandemic before them. This doesn't make sense, defies the current scientific evidence, and is also a due process and equal protection violation. All of the evidence and public messaging supports that we cannot have a jury trial in this case at this time with this jury. Moreover, under the order, civil trials have been postponed until at least 2021. On April 29, in her emergency order, Chief Justice Cantice Sequoia also stated in part, courts are clearly places of high risk during this pandemic because they require gatherings of judicial officers, court staff, litigants, attorneys, witnesses, defendants, law enforcement, and juries, well in excess of the numbers allowed for gathering under current executive and health orders. Other courts and other jurisdictions are not conducting trials through at least the fall. The Supreme Court of Texas suspended all trials. The U.S. federal courts in Connecticut, New York, Louisiana, and I understand Massachusetts is about to, as well as the Eastern District of Virginia, the Supreme Judicial Court for all state court trials in Massachusetts. Trials in Nevada are presently suspended in both federal and state courts. As COVID-19 infections continue to rise, health organizations are still releasing ever-evolving information, which illustrates how truly dangerous and potentially devastating COVID-19 is. This was an important one for us, Your Honor. We attached a recent letter from the World Health Organization signed by 239 scientists, which discusses the airborne transmission and how droplets can aerosolize and spread through distances larger than 6 feet. There is also emerging research that COVID-19 can be spread through air conditioning systems. Also on June 25, 2020, the CDC updated and expanded the list of people at risk of severe COVID illnesses, and as the court is aware, 3 of the counsel have submitted documentation from their doctors about their conditions, and of course the court is aware of Mr. Durst's own fragile health. These changes in the last few months of what the science believes the real chances of danger are increase the number of people who fall into higher risk groups. An estimated 60% of American adults have at least one chronic medical condition. The more medical conditions a person has, and we don't know what the medical conditions of the jurors are, we don't know what the medical conditions of their loved ones are or the people that they come in contact with, but the more the conditions, the higher the risk. It is clear that the pandemic in LA has spiraled out of control. We shouldn't continue with this lengthy trial under these dangerous circumstances, which would endanger everyone's health. More importantly, Your Honor, Mr. Durst's right to a fair trial has and will continue to be irreparably damaged. At the June 23 hearing in this matter, defendant requested a mistrial, contending that Mr. Durst's constitutional rights had been irreparably damaged by at best, a resumption date of July 27th be a 137-day delay caused by the pandemic. As we have set forth in all of our briefing, California courts have never sanctioned the denial of a mistrial motion based on a mid-trial day longer than 37 days. Most respectfully, Your Honor, after hearing argument, this court denied defendant's motion, relying heavily upon its reasoning that the defense had not requested an adjournment of potentially indefinite duration, and therefore holding that the Supreme Court of California's decision in People v. Gray was controlling. Respectfully, Your Honor, the defense renews its motion for mistrial to make clear it never requested a month-long or indefinite break in the trial, and for that reason and several others, Gray is distinguishable. Logan and Dismore cases of the California Supreme Court are common sense holdings about mid-trial continuances being per se prejudicial, and nothing in the Gray decision, most respectfully, Your Honor, truly contradicts those rulings. Showing actual prejudice is impossible unless the court is planning on a voir dire of the jury panel on what they've been doing and thinking for the last 4 months, which might take longer than a normal voir dire, like in this case, which only took 8 days. On March 16, 2020, at a relatively early stage of this rapidly evolving situation, defendant, quote, agreed to waive any issues arising from a 3-week adjournment. That's from the transcript of March 16th at page 2. The defense request simply did not contemplate a continuance of 137 days or more, nor did it constitute a waiver of any possible objection to a mid-trial delay of limitless duration. As the situation developed and it became clear that the delay necessary to protect the health and safety of all trial participants would extend at least several months and irreparably damage Mr. Durst's chance of receiving a fair trial, we filed our motion for mistrial. Also, Your Honor, it should be made abundantly clear that on March 12th, when we ended court, the jurors were instructed to return on March 16th. It appears that over the weekend, the court emailed and indicated that it was inclined to adjourn until April 6th, giving jurors and everyone else 2 weeks off before our scheduled week off for spring break. At that time, Mr. DeGuerin, Mr. Ray, and Mr. Lewis were not feeling well. They left and did not appear on Monday. I drove home to Las Vegas to take my wife home and drove back the same weekend to appear in court on Monday, March 16, 2020. I did not know the jury would not be there. It is not clear how the jurors were notified not to return on March 16th, but appears they were already excused by the court. And at some point, we would ask the court for some clarification on that. We filed the first motion to adjourn in open court on that day. We understood this to be a short adjournment, which was at the initial onset of the pandemic, and it was everyone's hope that our government and scientific community would have prevented the ensuing calamity. Moreover, the 3-week adjournment was soon mooted by the Chief Justice's order suspending all jury trials. It cannot be said the defense, quote, agreed, end quote, to an adjournment for all this time when the defense motion for 3 weeks was soon superseded by the highest court in the state, such that there would be no trial proceedings after mid-March for all cases. Our facts clearly distinguish People v. Gray. Respectfully, Your Honor, Gray did not affirm a denial of a mistrial motion, which was stated at page 36 of the June 23 transcript. In fact, no mistrial was ever asked for in Gray. Gray Court distinguished U.S. v. Hay, one of several authorities relied upon in our opening motion, on the grounds that the defendant in that case, quote, preserved the issue by moving for a mistrial because of the delay, whereas the defendant in Gray not only failed to object, but actively sought to delay by filing a writ petition that led to the stay of the trial. And that was to contest the degree of murder instructions that the jury was presented with that led to his conviction. The Gray Court repeatedly relied on this fact in affirming the judgment. Counsel's failure to object in any way, this is the Gray Court, and indeed his responsibility for instigating the delay, preclude raising the issue on appeal. Moreover, Your Honor, while this court correctly observed that proceedings in capital cases are technically unitary, they also indisputably involve 2 discrete parts, culminating in 2 separate verdicts. Thus, the interruption at issue in our case, occurring in the midst of the prosecution case, carries far more potential for prejudice than the delay in Gray after, quote, the jury had already returned a guilt verdict, but they had not heard any penalty phase evidence, and that's at 227 of the Gray case. In fact, the Gray case described the delay as occurring at a natural break in the trial. In addition, Gray was trying to question the validity of his conviction because of questions about whether or not the instructions were proper as to which degree of murder he was to be convicted of. The defense in this case, faced with an emerging and rapidly intensifying pandemic, only requested a 3-week adjournment to ensure the safety of all trial participants. In the ensuing 3+ months, the COVID-19 outbreak has raged on, resulting in delay far beyond defendants or anyone's control, Your Honor. Again, after the initial adjournment, LA County suspended all trials with a statewide suspension ordered by the Chief Justice of the Supreme Court just days after our initial hearing. This is a far cry from Gray, most respectfully, Your Honor, where the full amount of the delay was, quote, an inevitable consequence of the defendant's mid-trial pursuit of appellate relief. It is presumably for these reasons that the people did not, and I'm talking about the people in our case, did not so much as mention Gray in opposing the original motion for mistrial. In fact, to the contrary, they expressly agreed with our characterization of the mid-trial delay at issue here as, quote, unprecedented, end quote, that appeared at the people's opposition to our original motion at page 2. Quote, it is certainly true that this lengthy break in the trial is unprecedented in the annals of jurisprudence. That's from the district attorney's brief. Furthermore, the prosecution didn't even argue when we were last in court that Gray, a case that we originally cited, applied, and the case wasn't even discussed during our last argument, most respectfully, Your Honor, until the court read its decision. In light of the foregoing, the defense respectfully submits that the governing Supreme Court of California precedents are those cited in our opening motion, they holding that an approximately 2-month hiatus, less than half of the one at issue here, would create an impermissible risk of juror exposure to outside influences. Not trying to be facetious, Your Honor, this is not a gray case. This is a black and white case. People v. Logan, to continue a case for 2 months and allow the jurors selected to hear the evidence and render the verdict to, quote, roam at large during that long period of time cannot be countenanced in law. In Dinsmore, it said, these 12 jurors returning into the jury box after roaming at large throughout the county and state for a continuous period of, and that was 63 days, associating with their neighbors and friends and the world at large, and without the care and protection of the court for this long period, are not the jurors the law contemplates for the trial of a defendant charged with a serious offense. There is absolutely no indication that either of these decisions was superseded by Gray sub silentio, Your Honor. And here, contrary to the people's repeated suggestion, and probably different from cases from the 1800s where there wasn't the internet, HBO, Dateline, and other shows, there is a wealth of inflammatory and patently inadmissible information regarding Mr. Durst and the events at issue in this case available online, and I will not recite the sealed material that we filed with the court to give examples, but we are aware that the court and the people are aware of all the material that's out there concerning Mr. Durst, some up to the current date. With regard to jurors' ability to accurately recall the evidence presented to the adjournment, prior to the adjournment, Your Honor, the defense respectfully submits that the instant case is far from, quote, typical, as, end quote, as the court reflected at page 36 of the transcript from the last hearing. Whereas a typical juror selected to serve on a month-long trial would be engaged in the subject matter of the case on a daily basis, these jurors have been forced to spend the last several months focused on life and death matters regarding the physical health and economic survival of themselves and their families. We provided a declaration for Mr. Durst in our recent supplement. He agrees to the mistrial and understands it would lead to a delay of his trial. Again, he is elderly and at high risk, as the court is aware. But, Your Honor, he's also in federal custody through March of 2021 in relation to his conviction in the United States District Court, Eastern District of Louisiana, case number 2:15-CR-00091. Your Honor, we have submitted new letters under seal which address the health risks to Mr. DeGuerin, Mr. Ray, and myself, and of course, Mr. Durst also has his own serious health situations. We have attached as Exhibit 1 as to our new motion to adjourn a true and correct copy of an updated letter from Dr. Russell A. Klein, who attended court for the last hearing, which further discusses the health risk with proceeding with this trial. Why would we continue this trial in the face of increasing threat, Your Honor? We believe that this is the only jury trial that we're aware of in L.A. County that has been in recess for over 4 months with the potential to continue. The loss of work on jury selection, which involved only 8 actual days of voir dire of the prospective jurors, Your Honor, pales in comparison to the continuing threat, not only to everyone's health, but to the fairness of the trial that Mr. Durst deserves. To provide additional context regarding the jury selection process in this case, by our research, Your Honor, the prospective jurors completed a questionnaire between January 2nd and January 22, 2020. There were 414 completed questionnaires. Our jury consultant in this case, Lois Haney, and her staff began downloading completed questionnaires starting on January 7th. Ms. Haney was involved in a capital case in jury selection in Los Angeles until January 27th, and the court accommodated her schedule, postponing voir dire until February 2020. On Sunday, February 9th, Ms. Haney, Mr. Lewis, and myself met with Mr. Lewin and his team at their office in the airport courthouse to discuss jurors we could stipulate to excuse. I believe that we stipulated to the excusal of approximately 232 jurors. We weren't in the courtroom, and the jurors were not present. Voir dire of prospective jurors in court began on February 19th. Voir dire proceeded on the 19th, 20th, 24th, 25th, 26th, and 27th, during which time we exercised peremptory challenges and selected the 12 jurors to hear the case. Voir dire continued on the 2nd and 3rd of March, and the alternates were seated on March 3, 2020. In terms of time loss, if we were to try to use the present jury, please consider the need for a new intensive voir dire of those same jurors who, even if they do agree to return to our case, in order to see who's willing to serve and what they've been doing and what they've been thinking concerning this case, Mr. Durst, and their own personal problems. Without the juror questionnaires we proposed last time when we sought a mistrial, we don't even know if these jurors will return, what their attitudes are, or how they feel, which is completely unfair to them, Your Honor, and most importantly, unfair to a defendant on trial for his life. Consider the increased time it will take to try the case again with all the precautions needed to be in place. For example, 1 or 2 people in an elevator, spacing maintained everywhere. What happens, Your Honor, with the likely prospect of another stay-home or general shutdown, which the mayor and the governor have been discussing? How can jurors be expected to concentrate the evidence at a renewed trial with the constant, overwhelming, life-threatening, and economic concerns to themselves and their families? Your Honor, again, Mr. Durst is not going to be free on bail. He's presently incarcerated on another case to which he pled guilty. He still faces this lengthy trial, but Your Honor, please, it must be done in a demonstrably safe and constitutional environment. And presently that environment does not exist in Los Angeles, regardless of everyone's good intentions, including the courts. Not granting a mistrial under these circumstances will violate his rights and endanger the health of us all. The desire to avoid another jury selection cannot possibly outweigh all the constitutional and health concerns that currently exist. Mr. Durst wants the same fairness every other defendant would receive faced with an interruption of his case. That would be a new jury under the California law. It would also be a jury trial free from all the impediments to confrontation that the pandemic have created. He should not be the guinea pig for the new way that a trial is conducted, Your Honor, when it would be safer to mistrial it and schedule the trial for a point in time where a person can have an American jury trial. But people will put on their case for 5 months, which, by the way, could have been done in a month, and the jurors will be rushing home to get back to their loved ones. Mr. Durst has a right to present his defense, but the jury will not be able to evaluate witnesses properly because of masks, distancing, videotape witnesses, etc. We can't even sit next to Mr. Durst and converse with him, and the idea is to create some kind of a mechanical communication with a client, which none of the lawyers in this case have ever experienced in their many years of practice, Your Honor. Your Honor, under these unique and concerning circumstances, we implore you to reconsider your preliminary suggestion that you were going to deny the mistrial. Please understand, Your Honor, that we are not asking for this mistrial for any other purpose than to guarantee Mr. Durst a fair trial and to make sure that all the participants can remain healthy and safe to try many cases in the future, Your Honor. Thank you. I have some housekeeping matters, but I think I would like to wait, Your Honor, until the court analyzes what it's going to do with the mistrial, and then I can address those.
Thank you, Mr. Chesnoff. Mr. Lewin, do you have anything?
I do.
You may argue.
Your Honor, I'm going to divide this up because there are 2 separate motions the defense has filed.
And I only asked for argument on one, although I received argument on two.
Right, so I'm gonna
Your Honor,
start.
we're having difficulty hearing him.
Yes, let me,
Difficulty.
sorry. Does this work? Sound? Is it? So Mr. Chesnoff addressed, though Mr. Chesnoff addressed the mistrial motion, a lot of the strength of the argument would go to adjournment rather than to mistrial in the court's view. But do you wish to address both?
Yes.
Did I already go? Yeah.
All right, thank you, Ron. So let's talk about the mistrial motion. First of all, these are the identical arguments that counsel made previously. Identical. Nothing has changed. Now, what the defense seems to confuse, and I don't think it's unintentional, is they seem to believe that somehow if an adjournment, as an example, is agreed to, that there's a new jury. And that's an interesting point because, number one, it's not supported by the law, and number two, it goes to what the defense has been doing since day one in this case, which is they have wanted a mistrial for reasons that have nothing to do with COVID since the first day of jury selection. They've repeatedly asked for it. That's their right. Mr. Durst himself, Your Honor, as the court is aware, has made comments saying that he, quote, wants a do-over, unquote. And in the end, that's simply not what the court's role is, what the judicial system is meant to support. In the end, what we really have here is we have a request for a mistrial, and they simply don't meet the requirement. And let's go through, and again, I'm not going to take as long as Mr. Chesnoff, but a few things that need to be addressed. So first of all, Mr. Chesnoff makes a lot of just wrongly inaccurate statements. Number one, and it's almost laughable. No, this case could not have been tried within a month. It's absurd. It is not the people's fault or responsibility that Mr. Durst chose to kill 3 people, which necessitates a lot of evidence which the court has already found relevant and admissible. The amount of time that this case is going to take has been reduced by the stipulations that the people, in fact, were able to get the defense to agree to. That's number one. Number two, the idea that this is the only case in the county that has been delayed. That's incorrect. Judge Fidler is currently in the middle of a long trial. There's a third trial that I'm also aware of. I don't know who the judge is that is a gang case. And they're waiting the same way that we are. So let's talk about the actual mistrial issues. So they say, quote, we are in the midst of the prosecution's case. No, we've had 2 days of testimony. That's it. We've had 10 witnesses. And here's what's really interesting. Those 10 witnesses discussed the following. Mr. Durst's history of domestic violence, which he has admitted and which they discussed in voir dire. Number 2, Kathie Durst's upbringing, which is not in dispute in any way, shape, or form. Number 3, the circumstances surrounding the fact that Susan's dogs were loose and how the police responded to the location. So first of all, to even make the argument that somehow all this evidence has been presented in this trial and that it's so prejudicial to Mr. Durst, it's disingenuous. It's a tiny bit of evidence. It's evidence that's not in dispute. And there are 25 different remedies in terms of short of mistrial, such as having the evidence read back, having the audio of the testimony, which was all recorded, played back to the jury, having opening statements re-shown to the jury, having the court, if the court wanted, having us redo opening statements and recall witnesses. So that's the first issue. Now let's talk about Gray. And I do not like to say this, but it is true. My team, me, my responsibility, I'm the lead lawyer, we missed Gray. We looked at it. Gray is absolutely on point. Thankfully, the court was on top of things, and the court actually made the arguments, and the arguments are completely solid, completely supported. Those are arguments we should have made. Now, in the end, whether or not we cited the case really is more of a comment on where we fell short than it is on its applicability. That case is absolutely on point. And when Mr. Chesnoff says that, in fact, there is more prejudice in this case than there was in Gray, it's absurd, and here is why. As the court knows, guilt phase evidence is absolutely relevant in penalty phase. So you had a jury who heard an entire trial worth of material. Now they have their decision. They have one decision left, and that is the person going to get death, or are they going to get life without the possibility of parole? You had an 11-month adjournment in between that time, where if any court anywhere could say, you know, that is prejudicial to the defendant, that would be the case. The jury's left with 11 months of a heinous death penalty case for them to consider, which, by the way, although they're not deliberating, it would be hard to imagine that the images, the testimony, the thoughts are not going through their mind, much of which was disputed at trial, although the jury, in fact, ended up coming back and supporting the allegations the prosecution made, convicting, finding the special circumstance. So the idea that Gray is somehow substantially less prejudicial in this case, it's an absurd argument. And I know the court's aware of that as well. Number two, and again, they keep talking about the amount of time that took place. The fact that it's unprecedented. The COVID-19 pandemic is unprecedented. The problem with almost every case the defense cited, and the court again pointed this out, and we pointed this out in our prior motion, is that the reason for the original break in the trial, they range from a judge having a judicial conference to simply a witness was unable to come to court, and they just delayed things. So the problem there was not so much that a mistrial should have been declared, it's that in fact the original break in the trial violated the defendant's constitutional rights. Now, Gray discussed Hoy, and Hoy is helpful because, as the Hoy court explained,
It's Hay, I believe.
oh yeah, I'm sorry, Hay, excuse me, Your Honor, my vision here is not the greatest. Thank you. The Gray case explained that in contrast, the delay in that case, meaning Gray, came between the guilt and penalty phases. After the jury had all returned a verdict, but had not yet heard any penalty phase evidence. And they went back and they talked about what happened in Hay, where in that case, the court basically explained the jury could not be expected to adjourn that late in the case for a month and a half without forgetting any of the relevant evidence. So the problem is that where the adjournment came in Hay was completely different than where it came in Gray, and it's 10 miles from what happened in this case. They then say that Gray is, and let's get the wording right here, they say that Gray is not controlling and that it's distinguishable. Well, it's absolutely controlling. It's from the California Supreme Court, and they have not done even a rudimentary job of explaining how it is distinguishable. It is not distinguishable in any meaningful manner, and in fact, the Gray case, which I think the court would concede, is a substantially closer and potentially more prejudicial situation for the defendant than anything that Mr. Durst faces here. Now, excuse me, as the court pointed out, in Gray, the defendant also requested the hiatus, the adjournment, and the defense, in fact, did so in this case. Now we get to, and this is where it overlaps with the adjournment issue. Now the defense says, and again I found this very interesting, they say that they requested only a 3-week delay. Oh, that's not true. That is what you call, Your Honor, and there's just no other way to get around it, it's a lie. It's untrue. It's unsupported. Here's what they requested. And this is from their original motion. Quote, Mr. Durst will move for an adjournment of the trial due to health concerns for the jurors, defendant, attorneys, court staff, and the general public, and for the protection of the defendant's constitutional rights. It continues. The defense requests that this trial be adjourned until health and government officials can properly assure the safety of all attendees of this trial. Now, here's what's interesting and sloppy on the defense's part, is that statement in no way limits it to any specific length of time. It talks about actually until and in fact, in essence, this pandemic has been resolved and it's safe.
So my memory of this, actually, I looked at the transcript of the hearing on the motion to adjourn. Mr. Durst was present, and though the motion for adjournment had called for delay until safety could be assured, in the context of Mr. Durst agreeing, it was almost suggested perhaps a 3-week delay, and then Mr. Durst went along with the 3-week delay, and that's where this 3-week idea came up. The issue, though, is not waiver. It's just not relevant, it's not material, that whether or not Mr. Durst waived or agreed to this delay. What really matters is whether there is good cause.
Right.
And so what the motion was for an unlimited delay. This in-court colloquy doesn't limit that.
And in fact, Your Honor, the court granted, the court's wording by my memory was, I will grant defendant's motion.
Correct.
And that's what the court did. So here's what's interesting. The defense says we had no idea at the time that the court was going to adjourn for more than 3 weeks. That's untrue. Counsel was coming in at the time explaining they had no idea when it would be safe. The court was present on numerous phone calls, on emails, where they reiterated the same point. But here's where the rubber meets the road. When you look at their new motion, they use the identical language for the adjournment that they used before. Identical. So the idea that, well, we thought it was only going to be 3 weeks. They're certainly not requesting 3 weeks now. It's disingenuous. It's not true. Now, let's go back to the adjournment issue in a little more detail, because I think this is going to be important. Their current motion for adjournment, Your Honor, what they have mixed up is that just because there is an adjournment does not mean in any way, shape, or form that you get a new jury. And let's be honest, what's going on here is they want a do-over. So here is what the people are going to propose. Number one, Your Honor, and I'm going to refer back to the supervising judge Oda's memo, which was circulated, was given to our office. It went around back on June 29th. And that document discusses, and let me get the language exactly. One moment, Your Honor. The document discusses and lays out that counsel and courts are encouraged to have as many jury trials converted to court trials as possible. So we make the offer today, right now, knowing how much both sides respect this court, how much admiration both sides have for this court. We are more than willing today, Your Honor, to right now agree that we continue this case as a court trial whenever the court deems that it be safe. That then eliminates any issue of jurors. And if in fact counsel is interested in doing this trial and has the same respect for the court that they have previously related, I'm sure they'll take us up on that offer right now.
Well, let them talk.
Okay, so I'll leave that percolating with them as I continue my argument. So now let's look at the motion for adjournment in a little more detail. Let's assume that right now the defense gets their wish and we get, quote, a do-over with a new jury. How on earth are we ever going to be able to pick a jury? I have seen some of the and have heard from different people what the proposals are for jury selection. Mr. Chesnoff in his last argument said, well, maybe it'll take an extra month for jury selection. It will take us a year to select a jury. We're going to have to voir dire in tiny amounts. And that doesn't even bring up the idea of how difficult it's going to be, not just the process, but getting jurors who have the ability to serve. It's going to be nearly impossible to put on a trial like this until the pandemic is completely gone if we are picking a new jury from scratch. Now, thankfully, and again, counsel's motion for adjournment, if granted, in no way puts us in the position where we get a new jury. So here is the second thing I would propose. Second thing I would propose, Your Honor, is that, and again, I'm not a mind reader, the court knows better than I do, and I do agree with one thing that Mr. Chesnoff has said, and that is clearly the pandemic is not getting better. We had hoped that summer it would be hot and it would go away. It's getting worse. I think that the idea of inconveniencing this jury by saying, okay, come back September whatever, come back November whatever, come back January whatever, it's almost, really what it is it's a permanent delay by installments. And all it does is inconvenience them. This is what I would propose. Let's have the jurors come back in April 2021. Our same jury. They will be told at this point in time, you know what? You don't need to worry about this case at all until April. You make your plans, you do what you want to do, and when April comes, if we are in a position where it's safe, we will pick it back up. If not, then we'll wait until June. But the bottom line is, and if you look at it, those jurors are going to be in a much better position. They've already been voir dired, they've already filled out questionnaires, and if we start from scratch, not only will it be impossible to get a jury, Your Honor, but we're going to inconvenience 800 people for a year, 600 people, whatever it's going to be, because they have to stick around throughout the process. And by the way, we're probably going to have to inconvenience a couple thousand, because if you look at it, the amount of jurors that are likely to be able to serve after this pandemic with health issues and health issues of their families and school issues with their children, it's going to be nearly impossible. So our proposal would be that we put this case over until April. I think that probably, from what I read at least, that should be after the flu season. Tell the jurors to come back on that date. The court will periodically advise them. But we keep the same jury and we pick up right where we left off. Now, if, when we restart, the defense wants to either re-show opening statements, which were videotaped, they want us to redo the opening statements, we can certainly talk about it. My position would be, Your Honor, that the fairest and most equitable way to do things is, if the jury, the court decides, you know what, we need to redo the opening statements, we play them on the machine just as we are playing half the testimony of this case. And we go from that point. Now, if the defense is sincere in their issue that this is about COVID-19, then they should jump at this proposal that I'm making right now. This allows them to be safe, it allows their client to be safe, etc. If the response is, well, we can't do that, we're going to be prejudiced, etc., then the court has to kind of look behind and say, you know what, is this really only about COVID? And I want to add something else. I want to make sure, Your Honor, that each of the defense attorneys in this case is going to end up signing a declaration under penalty of perjury that they will not be appearing in a courtroom in any case during the interruption of the trial. According to Mr. Chesnoff, Mr. Ray and himself, Mr. DeGuerin, are in high-risk positions. I should also add, because I don't know if it was really explained as effectively as it should have been during the last hearing, Mr. DeGuerin, the defendant, has already waived his presence for the trial based on health issues. The court remembers they got a continuance, which we opposed, because Mr. DeGuerin had a heart ailment. And at that time, we spent a long time in chambers discussing, and the court agreed, if we have one lawyer per side, we're going on this thing, and that Mr. Durst specifically waived Mr. DeGuerin's presence if he were unable to be on the team during the pendency of the trial. Now, the idea, and Mr. Chesnoff suggested it last time, that in essence, well, that was Mr. Durst waiving his presence for a heart problem, not for COVID, is absurd. He waived his presence if he were unable to perform his duties as a lawyer due to health concerns. So Mr. DeGuerin is not a factor. Mr. Ray, the court has already said that when the case starts, Mr. Ray need not be in the courtroom. That's number two. Mr. Lewis, from what I understand, is not a part of the notes from doctors. We don't have them, but it's my understanding that Mr. Lewis has not filed anything, that he is ready to be on this trial. Now, obviously, I think he agrees with the request for the adjournment, from what I understand. And then we're left with Mr. Chesnoff. So, Your Honor, in summary, we are prepared right now to agree to an adjournment until April of 2021, using the same jury, no do-over, no change in stipulations, no change in opening statement, no change in defenses. We pick up where we left off with this jury, and we make accommodations as they are needed when we get to that point. With that, I would submit.
Thank you.
Your Honor, David Chesnoff.
Yes, please.
I'm going to make a few responses, and then I'm going to ask the court to maybe take a brief recess so that I can caucus with my co-counsel regarding these new ideas that we were just told about this morning. We didn't have any advance notice, so
Yes.
if the court is inclined to give us maybe a half-hour break so that we can talk, that would be helpful. But I'd like to make a few brief comments, if I could.
Yes, first make your comments.
Thank you. First of all, Your Honor, I am surprised that the court continues to countenance these kind of derogatory claims about our intentions here. I really would like the court perhaps to make a finding that they believe that what we filed not only has been an effort to provide you with the law, but to try to distinguish in a proper way, the way lawyers do, the case law, that nothing's being done here for the sake of getting a, quote, do-over, but rather is being done based on California Supreme Court precedent that said a mistrial is appropriate with a delay like this. It's the first thing we found when we began to research this. The Gray case, in our opinion, is distinguishable. The court may differ with us, but to adopt a differing opinion from us based on this dismissive attitude that Mr. Lewin gives, or this ridiculing attitude that somehow we are being disingenuous or we aren't making sense, this is the collective work of a lot of very, very concerned and disciplined minds. I'm not including myself in that. I'm talking about the people that helped prepare all of this work, and I feel like an obligation to them, considering the amount of effort that's gone into this on almost a daily basis, Your Honor, to stay on top of this, to make sure that Mr. Durst's rights are protected. That said, and we aren't trying to do the case over, Your Honor, or do the case so we can be on a dateline, Your Honor. We're trying to get a case that at a time that's appropriate, with a jury that is unaffected by a delay. And most importantly, Your Honor, Gray asked for the delay. In this case, God asked for the delay. We didn't cause this. And I know the court made the comment about the 3-week delay. Your Honor, at the time, we were going week to week to week. I asked for 3 weeks at that hearing. It's in the transcript. We were all kind of in limbo and not really knowing what was going on. So it's very clear that anything that's happened, even after that hearing, was superseded by the court's own, not you, Your Honor, but the higher court's own decisions about what would happen with trials. Your Honor, we discussed things in voir dire with the jury, like a domestic violence, and Galveston, only because the court had pretrial ruled that that was coming in. So for Mr. Lewin to suggest that we brought it to the jury's attention, of course we did. We had to. We got faced with having to deal with an acquittal in Galveston evidence, all of this stuff about domestic violence, which was exaggerated in the presentation of the witnesses with and unnecessary. As Mr. Lewin said, Mr. Durst admitted to domestic violence, but we were stuck with the prejudicial live testimony about domestic violence, and the court remembers we filed necessary motions in limine about both issues. Your Honor, we don't believe that Gray applies. We believe that the older California Supreme Court cases, which have never been reversed, apply. We would like, Your Honor, for the court grant the mistrial so that when the time is appropriate, we can have a new jury that is free from the impact of the pandemic. It is free from any outside influences which the California Supreme Court recognized per se exist in a case especially where there is so much information about Mr. Durst out there. And please, Your Honor, you know, we've been doing this together for a long, long time, and yet every time I work hard to prepare and make a cogent argument as best I can, I get told that I'm doing this for ulterior motives. Your Honor, believe me, David Chesnoff wants to try this case. I'm not trying to do anything here that actually helps me. Everything that's happening here is
a case where the defense asked for a mistrial, and in Gray, the Supreme Court noted that no mistrial was requested, and so that's really close to terms of not only the reason for the delay, but also in Gray's dispatching all the various claims of potential prejudice. back on the record in People versus Robert Durst. We have defense counsel on the phone.
Yes, thank you, Your Honor. Everybody that was on earlier, this is David Chesnoff, is on again.
We have Mr. Lewis here, and all of the counsel for the people are present.
Thank you, Your Honor. First, thank you for giving us a break there, Your Honor. The first thing we realized that when we got on the break was that in order to give the court an answer on the proposals, we have to visit with Mr. Durst. So we would like to ask the court to reset a status conference in 2 weeks, which will give us time to have somebody visit with Mr. Durst and discuss the proposals which defense counsel are considering, and we will make appropriate recommendations, and we'll have an opportunity to have Mr. Durst give a reason to answer to the question. So we would like the proposals to remain open until we have a status conference, if that's okay with the court and the people.
I will need to contact jurors immediately to let them know that there is going to be a delay, and also to give them the characteristic admonition. Perhaps I can do that in an open-ended way. I do intend to grant an adjournment, and I think the people's proposal is excellent. So, Mr. Lewin, how would that be? Shall we keep it open-ended, and then consider whether a jury returns at all, whether it will be a bench trial,
Yes.
or if the jurors are to return, should it be, I would say, April 5, first opportunity
Your Honor,
in April.
I have a request from Mr. Balian.
Oh, can we do April 11th?
We climbing another mountain, Mr. Balian?
No, it's just, if there will be any potential college tours, it would be that week up to April 11th.
Very important.
Was that April 11th, Your Honor?
That's what Mr. Balian has suggested.
Well, considering my affection for Mr. Balian, we will tell Mr. Durst that's the date if the court agrees.
That's a Sunday.
Oh. Well, not yet.
Good to hear you chuckle, Mr. DeGuerin. I recognize that laugh. All right.
Actually, I was on mute, so that wasn't me.
No, that was me, Don Ray, Your Honor. Sorry.
Don, you're sounding more and
I
more
was
like
mimicking his laugh.
You sound more and more like Mr. DeGuerin every day. All right, April.
Thank you.
April 12th is the proposed date. Very well. If the people agree that it's reasonable for me to delay a couple of weeks, then when we'll set a new date in Department 81 for. So April 12th, I presume we would set it here in Inglewood, because even if the conditions ease, I expect we'll still need to maintain social distancing. We will need the space that only this courtroom provides us, and which Department 81 does not. So, but as for the status conference, that can be in Department 81.
And, Your Honor, will that be at 9 or 10? Well, we haven't given the date yet, but whatever date that is.
We'll say it'll be 9 a.m.
Okay.
I'm sorry, did we pick a date? I didn't hear the date.
So, no, the status conference would be, we picked a time. Now let's pick a day. You say 2 weeks. What day works for everyone?
August 3rd, 4th?
I can't do the 4th. I have a potential preliminary hearing. Other than that, Your Honor. So for me, it would be better if it was, I could do right before. I could do the 31st, if that works for the court.
31st is fine with me, Dick DeGuerin.
Is that good for you, Mr. Lewis?
1 second, Your Honor.
That's a Friday, Chip.
I don't have just 2 cases, John.
Yeah, I think so.
Your Honor, 31st will work.
All right. 9 a.m., July 31st, Department 81, status.
May we appear telephonically, Your Honor?
Yes, you may.
I'm sorry, did you say nay or you may?
He said you may.
Nay? Okay.
Your Honor, and with respect, I know that just as we're all considering something that we were discussing, one of the problems, and I'm saying this for the defense's benefit as well, is that coming into flu season, the position we're going to be in is that if somebody gets the flu, we're probably going to have to treat any flu as if it's COVID.
Yeah.
Because we're not going to know the difference, and because it's almost impossible in a normal flu season that we're not going to have flu going around. It just seems to me that we really need to get ourselves past this flu season.
I think that's wise.
Okay.
I agree wholeheartedly. And so the telephonic meeting, July 31st, the other, Department 81. Now, as far as Mr. Durst, you'll want him to appear on that date?
Well, it depends on what his decision is, I guess, Your Honor. So we can advise the court if it's going to be a waiver or whether or not he'll be there in person, if that's okay with the court.
Your Honor. Just a moment, Robert. It's going to be 31st. I see. We'll vacate it if we receive a 977B and if I accept that 977B waiver.
Your Honor, it's my intent, I'll travel back out to see Mr. Durst and communicate these options and provide our advice. I will let the court and the people know as soon as that has happened. And I'll visit with him about the waiver as well.
Very good. Now, otherwise, the other...
Your Honor, may I ask a question? Is it 9 a.m. or 10 a.m.?
9 a.m. Now, counsel, did you wish to demonstrate this system for the court and maybe Mr. Lewin?
Your Honor, is there another date beyond the 31st consistent with what Mr. Lewin was saying about the flu?
So
it's not the April date? Or not?
I have not set any other date. If we have an April 12 date for the jurors, I thought a March date for status, but it's premature for us to do that right now. But I expect we'd meet ahead of the jurors by a couple of weeks or a month, 2 to 4 weeks. So the next date would be July 31st, and we'll just put the jurors on hold. I don't want to give them false hope if for some reason we didn't, although I expect you'll all agree.
Your Honor, with respect to the other issue, that's Mr. Bailey and Mr. Milius's and Mr. Miata's show. They've been working very diligently, and I think they're ready to give the court a...
We can do that. We just asked for maybe a 5-minute or recess so we could set up the conference with the remote person, if that's the court's inclination.
All right, and this doesn't even need to be on the record. It is simply a demonstration of this technology. I should say that as to remote testimony, if conditions improve, we won't need it. But if conditions remain as they are, I've as far as the as far as remote testimony, I've essentially given my blessing, but I think I need to do more than that, and I think now I ought to incorporate by reference the Chief Justice's general orders describing the circumstances of COVID-19 and the pandemic, and I think I will incorporate by reference what both sides have demonstrated quite elaborately in their briefs about the dangers to participants of being present particularly if a person is vulnerable on account of pre-existing conditions or age. So that part is important. The second part is whether or not the technology itself appears suitable to the court. The third part would be a specific showing as to each witness that these conditions would apply to that witness. Again, I hope to avoid all of this, but in the event that we need to take any remote testimony, I do want to see that this technology is satisfactory. Okay. And I know that and all defense objections are understood and preserved, but I want to see.
Thank you, Your Honor.
But I want to see the technology for myself.
Your Honor, just so I understand, it's my understanding that the defense is going to be talking to Mr. Durst about both proposals. One, the adjournment, and two, the court trial. Am I correct, Mr.
Yes,
Chesnoff?
Mr. Lewis is shaking his head in the affirmative.
That's
Okay.
correct.
That's correct,
Thank you.
according to Chesnoff.
And I assume, Your Honor, if it's a court trial, we would proceed, in the near future.
So this all is subject to discussion.
Right.
We have more flexibility with the court trial as to witnesses, as to scheduling, as to appearance in person or remotely. All these things can be agreed. Many of these protections are many of these are constraints of a jury trial are designed to for that purpose, and there's just much more flexibility. So that is all subject to discussion.
Agreed. Okay.
Agreement or disagreement, but I hope that we could reach agreement easily on the format. So with that, should we take a recess, and then I'll observe this technology? It doesn't need to be on the record. Robin? All right. Is there anything else from counsel on the phone?
No, thank you very much, Your Honor. Stay safe.
Thank you. You as well.
Your Honor, the one issue was, and I guess we'll deal with it when we adjourn, when we come back in 2 weeks. If the court grants an adjournment, we are going to be asking that counsel put on the record in an affidavit that they will, pursuant to what they've said in their declarations, they will not be appearing in court. That would not apply to Mr. Lewis, who was not filed, as my understanding, is not saying that he cannot be there, but we would be requesting that. We just want to make sure that the defense is aware.
Okay, we can talk about that when we come back.
Thank you.
It's obviously I take them at their word, but we'll discuss it more in 2 weeks.
Trust but verify, Your Honor, would be the people's position.
Very good.
Okay, I'm going to disconnect now.
All right, goodbye,
Sure,
Kathie.
Thank you.
I'll recess so that you may set up the technology. Thank you, Your Honor.